It's not possible.
I didn't say it would be easy, Neo.
Know how that worked together in combination with the injection. Thank you.
Yeah.
What's going on with the assessment for the, oh, he was on outpatient. Anything happened with the assessment at the jail so far?
Nothing, Your Honor. I keep asking and don't get any answers.
Mr. Pacini, I think you met yesterday with one of the members of our AIM division, right? And I think she was asking you what, you know, she was trying to help arrange the assessment further, right?
Yeah, she was, we were trying to figure out which outpatient I wanted to go through. And I know once I start outpatient, they redo an assessment when I go in for that. So I don't know if you guys will need a copy of that. I had a quick question though. I was talking to the nurse the other day. Is it possible that they give me the Suboxone before I leave? Because
That's my understanding.
okay. Yeah, because she didn't sound so sure about it when I talked to her last week, but
It should be possible, is my understanding as well, through the MAP services. So you should be able to get that.
All right, I'm ordering that he's on home confinement to the 1752 Washington Road address. He must do the intensive outpatient treatment and intensive testing.
So
He must have the Suboxone prior to release. He must have taken a prescription, so I'm clear, prior to release. Okay, and he must attend the
this turn's already
Tuesday 9 a.m. appointment for a Sublocade shot, and I need proof of that.
could I ask one quick question?
Yes, sir.
So if for some reason they don't get me the Suboxone prior to Tuesday, when my appointment's set up, what should I do? Do you have any suggestions? Because
You need to talk to your attorney about that, sir.
Mr. Pacini, I will check if you're still in there tomorrow. And if you are, I'll reach out to Ms. DeVue and I'll come see you tomorrow. Okay.
Okay. All right. Thank you. All right. Thank you.
And then I'm gonna put it over a week again to see where we are. 3/21
No, the cocaine.
24
PW. This was supposed to be
at 9 a.m.
I'm
I'm sorry, 10 a.m. This is a VLP.
No, I just ordered.
Thank you, Your Honor.
Right, thank you.
Thank you, Your Honor.
What you did.
State of Michigan versus Joseph Varney, case number 23FB 2412.
Something different for the people.
Thank you and good morning, Your Honor. Joseph Hall appearing for and on behalf of Mr. Varney, who appears via Zoom. I see him logged in there. Mr. Varney, if you could unmute, turn your video on, and say your name for the record, please.
Joseph Leonard Varney.
Thank you very much. Your Honor, we are here today for sentencing. To that end, my client and I have reviewed in full the pre-screening investigation report. There's only one correction to the sum and substance of the report that we proposed, and that is in the section headed substance abuse on page 2. It indicates that the reason that Mr. Varney has never used any controlled substances is that his brother died from an overdose when he was 18. In fact, it was his father who passed away when
Okay.
Mr. Varney was 18, and that is the cause for his lifetime sobriety from controlled substances. Other than that, Your Honor, we have no corrections, additions, or deletions to propose to the body of the report.
Thank you, Ms. McDuffie. Anything regarding this particular sentencing?
I just echo the concerns from probation in the PSI. It doesn't seem as if I just don't know if the relationship that Mr. Varney had or has with his children is coming through there. Even in the end where he's saying now I have this case because this stuff happened, and he didn't seem to, and I don't know what relationship he wants to have. Moving forward, I understand that right now, I don't, in the interest of safety and everything else and healing, I think for everybody involved that there needs to be separation, but I'm just a little bit confused about obviously why, but how this incident happened the way it did. And I don't know what to say about it other than, I agree with probation. This anger management has got to be a start. It seems like there needs to be a lot more, but I guess one thing at a time. That's all I can say.
And Your Honor, to that, I would say, I think confusion actually kind of makes sense to be Ms. McDuffie's stance here. One area that we have to understand that we occupy right now is that this report was drafted by virtue of the police report only, as stated from, and Mr. Varney's statements to Ms. Johnson. There was never any contact made, and Mr. Varney and I, to be honest, I think from Mr. Varney's end, we really wish that contact would have been made, because a lot of the confusion is coming from the fact that we're trying to glean these things from a police report and Mr. Varney's statements to Ms. Johnson. Your Honor, this incident in and of itself was very confusing, to the extent that at the end of the incident, after the officers had all arrived and right before Mr. Varney was taken, 2 out of 3 officers were in the huddle. And it's on video that Miss McDuffie has, that I have. 2 of the 3 officers were arguing that nothing should happen to Mr. Varney, right? And so I don't want the extent of this to be overblown, because we're trying to glean things from words on a page that can't be asked questions or followed up on or what have you. Mr. Varney, to his end, wants a full relationship with both his children, and he made great efforts to actually get a relationship going with his daughter in recent times. Additionally, Your Honor, there has been not one other incident in Mr. Varney's entire life of any sort of problems within the home, or certainly not violence. This was an incident, Your Honor, where Mr. Varney was awakened out of sleep to somebody trying to kick his door in. Now, regardless of, I can't imagine, I've never had to do that, Judge. I imagine that's startling in nature. The tussling that comes after, that's confusing in and of itself. But I think confusion is a good word to sort of describe this case. By no means do I think it means there is some habitualized pattern of activity or something full scale that we can talk about Mr. Varney's relationship with his children. For 99.9 and go on to decimal points of that relationship, it has been fantastic. The children are successful when they live with Mr. Varney. Tyree, the young man who is the subject of this charge, is in college, is doing positive things, having grown up and been tutored by Mr. Varney. His daughter Shayna has been succeeding more in her life in the time she has lived with Mr. Varney and his wife Chelsea than ever before. So, Judge, yes, this is a regrettable and certainly confusing incident, and Mr. Varney has owned it, Judge. This is not, I'm not backpedaling away from culpability, but before we go and make this something beyond what it is on the page, an assault and battery, I think I wish we could have had contact with the children to fill in the blanks here before we assume on a confused basis that there's something much deeper here that requires something much deeper. I think that goes too far. Your Honor, what I think the record supports, I think the recommendation is essentially fair. I was actually going to ask that Your Honor consider less probation on this case. Mr. Varney does not have a significant record. He has the support of his wife. He's doing positive things. He never violated one iota of anything while on bond. And I think he's a good candidate for that. As it stands, I think Mr. Varney's the type of defendant who will succeed no matter what obligations Your Honor puts on him. But I just want to push back against the idea that we should read between the lines here, and then what we find between the lines we should hold against Mr. Varney. And I guess I would leave it at that, Judge.
I'm going to respond just a little bit to you regarding the statements that you made. Ms. McDuffie probably has things she wants to say, but at this point, I'm going to put it like this. You are referring to the fact that we're trying to read between the lines. This is not a reading between the line type of scenario. This got completely out of control to the point where his son thought that his father was going to kill him. Now, I'm not saying that I fully understand what happened before those feelings and that part of the incident was occurring. I don't know how we got there. That's the problem. You know, you have a daughter who says that her fingers were slammed in the door based on the police report. And then you have a son who at no point in time says he was kicking on the door, but rather his father came to the door and actually grabbed him and threw him into bushes. I don't know what happened. I wasn't there. I accept your proposition that the police officers were confused and couldn't initially figure out who they thought was the aggressor to charge in the situation. I can accept all of that. But to try to recouch it as a simple A and B, that it is not. That it is absolutely not. We have him with Mr. Varney with black eyes. We have him being hit in the head with poles. This was a melee of a mess. And I completely accept that Mr. Varney has had no issues before. And I believe, I don't pretend to speak for Ms. McDuffie, but I believe her concerns align with mine, which are, how is the healing process going now? And what is going to be put in place to ensure that they are okay for their forever lives? That is what I think she's referring to. And that is the concern that I have as well. As I read this report, I tried to go back and see if I could figure out who was the aggressor, because when I read what Mr. Varney said, I get very concerned about how this came about. If you have a father who is trying to be a father and set curfews, and you have kids who are not abiding by those curfews, who decide that they will come home when they want to come home, and the door is shut, and then they're trying to kick in the door, that's one scenario. If you have a scenario, according to what the daughter says, where no one's kicking in the door, but Mr. Varney is not behaving in your normal parental manner and being very aggressive, that's a different scenario. And that's where the confusion is. Having said all that, Mr. Varney, because I'm still confused, what would you like to say, sir?
Thank you. I'd like to start with an apology to my family, to this courtroom. It was never my intention for the events of that night to escalate in the manner that they did. I've been without my children in my life for almost 5 months now, and the hole in my heart and my soul from that is pretty undescribable. I've managed to stay out of trouble the majority of my life, so this situation I find myself in today is unfamiliar and terrifying. Just moving forward, I want to vow to my family to never find myself in this situation again.
And I believe what you're saying. I hear your pain.
Thank you.
So our goal now is to try to figure out how to create a you that this wouldn't happen in the future for, and for your family. So that's what this is about. Um, I I think that the time frame that we're looking at for the A and B is sufficient, and it's adequate in the right amount of time. It's an A and B, so therefore you will be eligible for an early discharge when you complete half of that anyway. Um, there was just so much going on out there. I'm glad to hear that your children are doing well right now. As far as their careers are concerned, or the start of their careers, that does not say how they're doing emotionally, though. And you probably don't really know, and that's probably very painful too, because you don't have the ability to know. I'm gonna follow the recommendation, and I hope that at some point we can have a scenario where maybe everybody's in counseling so that you can move forward as a family. Well. I'm sorry, sir.
I said that is my hope as well.
Yeah. All right. It's the sentence of the court that you serve 93 days in the Washtenaw County Jail. Credit for 1 day served. 92, the balance of that is suspended, so you never have to do any additional jail time, sir, if you do what you're supposed to do here and trust the process, Ms. McDuffie, is there something you wanted to say?
I wanted to let you read the terms. I just had a question about if there was any specific order in which, because counseling was ordered, ABR was ordered, and I didn't know if Agent Johnson intended for him to do any one thing before he started the other.
All right, thank you. You're on probation, sir, for 18 months. Fines and court costs in this case for $525, $30 per month probation oversight fee. Meet with probation when and where directed, including any and all home visits. Make earnest efforts to maintain legitimate employment. Complete the ABR Domestic Violence Intervention Program, Early Intervention Program, and engage in family counseling. Sign a release of information. No assaultive or threatening behavior towards anyone. No contact with Shayna Varney or Tyrese Varney Bush. Submit to and pay and be responsible for random drug and alcohol tests as requested by the court, probation, or a police officer or treatment provider. No use or possession of alcohol, marijuana, illegal drugs, or drug paraphernalia, and no being in the presence of anyone using those or firearm components, ammunition, or other dangerous weapons. I'm going to do a review in 45 days. The way I think this should work, sir, is you go to the early intervention program. I think they do an assessment and determine how many classes you need. And then once you've done, started that particular program, you can start the counseling on your own. And then I think the counselor should be the person who sort of figures out whether or not it's time to begin the reintegration process with your children. So the sooner you do that, the sooner you can start to see your children if that's what they want. You have to give them the space to figure out what they want to. And I too, along with Mr. Hall, wish that we were able to reach them. So I don't know if they may be watching online or what, but if they are, I hope they reach out to probation so we can get a better feel for where they are with what they want at this point in terms of contact with you, Mr. Varney.
And Your Honor, I'm confident that will occur in the future because I believe Victims Advocates was having regular contact with them throughout the pendency of the case. So I'm really hoping this isn't the no contact or the inability to make contact isn't something that continues. Because like you both, I agree that getting people back in the in communication is part of the healing process here and will eventually need to take place.
Right. And, if they reach out to the court or to the prosecutor's office and indicate that they want that contact, the court will be notified and we'll try to start that reintegration process.
Thank you, Judge.
You're welcome.
Your Honor, there is one final issue today. I know my office tried to start communication back in February about a potential travel request for Mr. Varney. Mr. Varney, for a long period of time, has been a high-ranked amateur golfer in the United States. At one point, he was 9th in the country. He actually has a golf tournament beginning in Los Angeles, March 15th. He would actually get on a plane today, the 14th, and return on March the 18th, if allowed by the court. That was something we informed Judge Barr about, but given that Mr. Varney was going to see you today, Judge Barr deferred the decision and to your Honor's court. We did send a travel request, as I said, on February the 26th, but we have not yet heard back.
Typically, those are provided to me, so I'm not certain that it went through properly. They used them over to me. Defendant, is there any objection, Ms. McDuffie?
No objection, but you said it's in LA starting tomorrow?
It's in LA starting tomorrow, the 15th. He would leave today, get on a plane today. But he has already purchased the tickets and at his own risk.
The tournament, I believe, is the 16th, Joe.
The tournament is the 16th?
The 16th, yes.
All right. I'm looking at the email from my secretary that says it begins the 15th, but I appreciate you correcting the record. Mr. Varney, is it true that you would get on a plane today, though, to leave?
Yeah.
Okay. So it would be the 14th to the 18th would
Yes,
be the
sir.
day you would not be within the jurisdiction.
Yes, sir.
Okay, thank you.
Same return time, yes.
Anything else from you, Ms. McDuffie?
Nothing from the people.
I'll approve that trip.
Thank you, Your Honor.
I can send that to him here shortly, Your Honor, if he wants to send me an email to that effect, and I can get that to him once we finish court.
All right, thank you. And
Thank you, Ms.
need to
Johnson. Good to
reach
see you,
out
Ms.
to-
Johnson.
You're welcome, Mr. Hall. You're welcome, Your Honor.
You need to reach out to the probation department anyway, so that you can go over and sign your contract. And so if he's leaving today, are you going to do the travel request and do the contract when he returns? How do you want to do that, Ms. Johnson?
I can do the travel pass today, and then we can go over his contract when he gets back from his golf outing.
All right, so contact the probation department this afternoon. You have that number, sir?
I'll have my staff reach out to Mr. Varney immediately after the hearing, Your Honor, and provide him with all the contact information.
All right, and then I don't think I set the review date, so I think I still need to do that. We'll do a review in this case on May 16th, 2024 at 10 a.m.
Thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.
You're welcome.
Take care, everybody.
You too. State of Michigan versus John Garrett, case number 23 FB 1294. Ms. McDuffie, you were muted.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of John Garrett.
Mr. Garrett, please state your name.
John Garrett.
Thank you. So I thought Mr. Garrett was released to Bear River on March 4th. What's going on?
I had an emergency on the way to the jail yesterday, so I did not get to meet with Mr. Garrett, but he is still being held on a felony case. So I don't know why he wasn't released. Mr. Garrett?
I'm just waiting for I was assessed last week for Bear River, and just waiting for transportation to pick me up.
All right.
In the meantime, Your Honor, we were also waiting on a couple of things. I did see Mr. Garrett was arraigned yesterday, it looks like, on the retail fraud. That is a felony. And his, let's see, first PCC for that is on the 21st. There is still, I believe, an outstanding controlled substance warrant. I attempted to try to get that charged or charge it. I haven't been able to make progress on that yet, but I'll keep trying. So, but we have one of the two outstanding cases. But unfortunately, I believe that I saw about 2 or 3 other cases come in recently for Mr. Garrett as well. So I'm just trying to look through here. Those came through, I think, since our last pretrial.
They did.
Yeah, they're out.
Yesterday. Yeah.
Okay. So I have to kind of go back and take an inventory of what all is out there because I was waiting on 2 specific ones and then some more came in.
All right. So, Ms. White, what is your request?
I'm asking for an adjournment so that we can get everything together.
Do we have any idea how long that might? Well, I'm looking at April 4th. Do we have a better idea by then?
Well, he has a court date of April 2nd, and then the bonds on those are $1, so that should be fine. What do you think, Ms. McDuffie?
On the one hand, I kind of doubt that all of those outstanding warrants are going to be authorized and that a bond would be set that would interfere at this point with him in Bear River. I think it's more likely he'll be released to treatment before those get done. So.
Would you like a longer time, a later date?
No, I think actually it may be better for him to go ahead and get in treatment, and then I can make a note if I'm at least send it to the other prosecutors that says this defendant is currently on bond for these cases in treatment, so that's known when he does get arraigned on.
All right, April 4th, 2024 at 10 a.m. Bond is continued with release to treatment, long-term treatment, inpatient.
It's 90 days, Your Honor.
Okay.
Okay.
Thank you, sir.
You're welcome. Thank you, Judge.
All right. See you on the 4th, sir. State of Michigan versus Kerry Jones, 23S00828, as well as 431-7487.
Richmond, Deputy for the People.
Assistant Public Defender Sandra White on behalf of Kerry Jones.
I think this maybe should be a township matter. Is that correct, Ms. McDuffie?
I think this one is actually mine.
Okay.
Yes, I did check.
State of Michigan. All right, we're here for a pretrial in this operating without security matter and for a show cause in the improper lane case.
I sent Ms. Moeller an email, I think it was yesterday or Wednesday. Mr. Jones can have the civil infraction as far as a no insurance misdemeanor, but I let her know I was not extending any offers for the civil for the lane use.
The lane use is already on default.
I thought it was a pre-hearing on the docket.
We did too.
All right, well, let me see here. Let me check on this ticket and see if we can. It is not. It is a pre-hearing. You're correct. Okay.
It is my understanding that Mr. Jones is going to admit to both of them, accept the offer and admit to the improper lane. Did I say that correctly, Ms. McDuffie?
Not quite, but so my understanding is he's going to accept responsibility for an added count 2.
There we go.
Traffic on case number 23S00828, and he will be accepting responsibility for the improper lane ticket. Is that correct, sir?
Yes, Your Honor.
All right, please raise your, nope, you don't need to raise your right hand. And for events that occurred on Did you say your name on the record already?
No, they, yeah,
Could you do that for me, please?
my name is Kerry Jones, Your Honor.
Thank you. And these are both for an event that occurred on December the 16th of 2023 at the vicinity of Textile Road and Bridge Road here in Ypsilanti Township. Is that correct, sir?
Yes, Your Honor.
All right. I'm just writing it up. As far as the 23-00828 is concerned, the fine in that case is $180. And for the improper lane, it's $130. Can you pay that today, sir?
No, I was assured that my defense attorney, I guess they didn't inform anybody that I could pay it on the 28th.
On the 28th of March, you can pay it?
Yes.
All right. One second. So March, okay. I'm gonna give you to April 1st.
Okay.
If you don't pay it by then, a 20% penalty will be added to it, okay? So please pay it by then. And then what I'll do is schedule you to come back to see if it's paid on April 4th. So that'll be at 10 a.m. If it is paid, sir, then you don't have to be here, okay?
Yes, Your Honor.
Otherwise, I'll see you back to explain why you haven't paid it. You have a good day, okay, sir?
You too. Thank you.
Count one is dismissed in the case. State of Michigan versus Artia Tomlin, case number 23-00544.
Rachel McDuffie for the people.
Assistant Public Defender Donathy Lieb on behalf of Ms. Tomlin. Ms. Tomlin, could you unmute and state your name, sir, ma'am? Ms. Tomlin.
It's just now coming in and getting connected. Ms. Artia Tomlin, please unmute, state your name.
Artia Tomlin.
All right, please also turn on your screen, ma'am. We're here for a pretrial, an adjourned pretrial.
That is correct, Your Honor. Ms. Tomlin did complete an assessment with Mr. Statman. I did provide that to Ms. McDuffie. However, I've been advised that the state is not prepared to make any offers for reductions in this matter, and therefore Ms. Tomlin will be pleading guilty as charged today.
All right, Ms. Tomlin, it's my understanding that you are going to be pleading guilty as charged. This is a misdemeanor carrying a maximum penalty of up to 1 year in the Washtenaw County Jail and up to $1,000 fine, and the charge is operating while intoxicated with an occupant less than 16 in the vehicle. Do you understand that, ma'am? Ma'am, you need to turn your screen on. Ms. Tomlin, did you hear anything I said, ma'am?
Yeah, I heard the part up to $1,000. I don't know. I keep clicking off.
Okay. And you understand that the charge is operating while intoxicated with an occupant less than 16 in the vehicle?
Yes.
All right. Is that what you want to do? Plead guilty to that charge, ma'am?
Yes.
All right. Please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may lower your hand. I'm going to go over some rights that you have that you're going to be giving up by entering into this plea. Please stop me if you have any questions or if you feel like you need to speak with your attorney again, okay?
Okay.
You have the right to have a trial by a jury, at which time you can call witnesses to speak for you, you can get an order signed by this court to require that those witnesses come to court. You have the right to see, hear, and question any and all witnesses that are called against you, and you have the right to be a witness for yourself, or you could choose to remain silent if you chose to remain. Oh boy, Ms. Tomlin, your connection is really not good. I'm not sure what you heard.
I'm not sure why. I'm at home.
All right. Where did you hear? What did you hear last, ma'am?
You was telling me about what it could carry up to, I think.
Oh, okay.
Oh no, about the trial, waiving the trial and stuff.
All right. You have the right to have a trial by a jury, at which time you can call witnesses to speak for you, at which time, if you want it, you could get an order signed by me to require those witnesses come to court. You have the right to see, hear, and question all witnesses that are called against you. You have the right to be a witness for yourself. Or you could choose to remain silent. If you chose to remain silent, she is gone again. This is not going to work.
Your Honor, I wonder if perhaps we should adjourn this to a time when Ms. Tomlin can use the Zoom facilities at the courthouse.
I think we probably should. Ms. Tomlin, this is not going to work this way, man. I'm going to adjourn this to April 4th, 2024 at 9 a.m. Ma'am, you need to come into the courthouse or be on a device that will work.
Okay.
So you can come here and use the Zoom facilities here. If you don't have one of those going, then you consider not being in court. So you need to make sure that your devices are working properly or you're here at this courthouse, okay?
It's raining, so I probably have my internet is probably missing that, but I'm at home and I normally Zoom from home every time. So I don't know, kind of live in the country and to be running the connection be bad, but I Zoom from home every time. So I'm not sure what's out today.
Well, I can't make out what you're saying for the most part at this point, and I think she might be gone again. Bond is continued.
Thank you, Your Honor. I'll give her a call and make sure she knows when to come back.
Thank you. State of Michigan versus Darius Prince, case number 23S00408.
Deputy for the people.
Assistant Public Defender Allison Muller here on behalf of Darius Prince. Mr. Prince, can you unmute and state your name for the record, please?
Yes, my name is Darius Prince.
Thank you. Thank you, Mr. Prince. I can't really see you.
Hold on.
You got some weird...
I'm at work.
Oh, okay. Thank you. All right. Yes, that is much better. All right. We're here for a pretrial today?
Yes.
Yes, Your Honor. We would be requesting an adjournment. Mr. Prince and I wanted to be able to set up a time to meet up and go over the media discovery in this and then to make a plan for the case.
Any objection? No objection? All right. Pretrial in this matter. Will be adjourned to April 4th, 2024 at 9 a.m. Bond is continued.
Thank you, Your Honor.
You're welcome. Have a good day, sir.
You as well.
Thank you.
Bye-bye.
Bye. State of Michigan versus Devon Ellis, case number 23FB 1258.
Rachel McDuffie for the people.
Assistant Public Defender Allison Muller here on behalf of Devon Ellis. Mr. Ellis is using the kiosk outside. Mr. Ellis, can you unmute and state your name for the record, please?
Switch it back again. Devon Ellis.
Thank you. This is supposed to be in person, so I think that we're gonna have to wait on that one. We'll bring him into the courtroom at in a little bit to get this one heard. Okay. And are you going to be able to handle it, or is someone else going to need to handle that since it's in person?
Your Honor, I think I'm not there. It would take me about 20 minutes to get there, so I'll see. I don't know. Will it be moved to the end of the docket?
Yes.
I am
Okay,
here, Ms. Mueller, if you want to send me the information. Unless you want to do the hearing.
No, that's
I'll
fine.
let the two of you talk about that.
Okay.
All right. Thank you.
All right, you guys can go over there. It's in person.
Need our data bank. The court will call a matter of the state of Michigan versus Lillian Dobbs, case number 23S00400.
Rachel McDuffie for the people.
Miss Lillian Dobbs, please unmute, turn on your screen, and state your name. Miss
Hi, Lillian Dobbs.
All right, we're here today for what is supposed to be.
I'm sorry, could you repeat that? We cut out.
All right, we're here today for what is supposed to be a bond violation and pretrial, and that was the previous bond violation. Now we have a new bond violation. Miss Dobbs' attorney is apparently not here today. Is that correct, Miss Dobbs?
Correct, he's on medical leave.
I don't know what that even means. You can't take medical leave for cases.
He's on medical leave, and
well, who's substituting for her from that office?
I have an email. Nobody. I have an email that says he's on medical leave. Okay. I was told to request an adjournment.
Ms. McDuffie, anything from you on this?
Your Honor, I don't know how the court would handle such a situation, but Ms. Dobbs, originally, she was issued a bench warrant for a previous violation. She retained counsel. That counsel appeared at her arraignment on that bench warrant before the magistrate and would have been given this date. I have never seen an attorney just not show up and send an email after filing an appearance with the court only to their client and not notifying the court or counsel or anybody else of their planned absence, and without sending anybody else to substitute. As the court mentioned, Ms. Dobbs has additional violations since that time. So obviously we can't proceed with her unrepresented, but I have a problem, I guess, with just simply adjourning at the same time because of the non-compliance. So I don't know if there's a spot appointment of the PD that could suffice for now, or what.
Well, I tell you what I'm going to do. Ms. Dobbs, you have been missing tests almost on a daily basis, and testing essentially when you choose to test.
Yeah, I don't want to speak without my
I don't want you
attorney
to
here.
say anything. Yeah, I'm not asking you to say anything.
Okay.
March 21st, 2024 at 11 a.m. in person. Counsel needs to be present or contempt proceedings will proceed against your attorney. So they need to be present or have a substitution. Counsel is very aware that you cannot just show up to court.
Okay.
I'll see you here in person, ma'am. If you have another missed test, I'm going to issue an immediate bench warrant. Do you understand?
Okay. Thank you.
Is that a yes, you understand?
Yes, I understand, ma'am.
All right, thank you. State of Michigan versus Ronnie McBray, case number 20S00203, as well as 21S00313 and 19FB1608.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Ronnie McBray. Mr. McBray, could you have the jail unmute you and state your name for the record, please?
Ronnie McBray.
Thank you. All right, we're here for a pretrial and show causes.
And an adjourned sentencing, Your Honor, I believe. But I don't think we're able to, I don't think the sentencing is at a point where we could proceed on that yet.
That's correct. Well, actually, it's two pretrials and a sentence. You're correct.
Yes, Your Honor, we received an offer from Ms. McDuffie. I discussed that offer with Mr. McBray, and I'm not sure how would be best to proceed. Basically, he wants to plead to the offer on case 20S00203. He would like one adjournment to consider the offer on the 21S case a little bit further. So I don't know if the court would like him to go ahead and plead to the 20S case or adjourn both matters out.
No, we want to know what's happening.
I'm sorry, Your Honor. I know the jail has a lot of background noise. I couldn't hear. We want to see what's happening on which case?
On as a whole. I don't want to piecemeal it. Let's turns out that he is going to not accept the offer from the other case. Then the other. So, does March 28th work for that?
Sorry, Your Honor, could you say the date one more time?
March 28th.
Okay, thank you.
March 28th, 2024 at 10 a.m. Bond is continuing. Did I say 10 or what did I say? Okay. State of Michigan versus Ronald Springer, 23S 4260059.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Ronald Springer. Mr. Springer, can you unmute and state your name for the record, please?
Yes, Ronald Springer.
Thank you. Good morning, Mr. Springer. How are you, sir?
I'm doing fine. Good morning, Judge.
Thank you. All right, we're here in this driving while license suspended matter. Mr. Springer, we're supposed to have a appeal hearing on January 30th. Where are we with this, please?
Yes, Your Honor, Mr. Springer had the hearing. Unfortunately, it was denied at this time, but he is eligible to resubmit the appeal. He does not have to wait for that year. I believe my understanding is that they want further documentation proof of his sobriety, so he plans to do so. In the meantime, my understanding is that Ms. McDuffie did extend an offer while that is taking place, that, you know, renewed appeal to let him admit to or plead to letting an ineligible person drive. And Mr. Springer would like to admit to that.
That's a correct statement of the offer. A defendant who's in revoked status is eligible to receive that upon receipt of the appeal paperwork. So ideally, if he had been restored, we would have been completely dismissed, but he can have that regardless of the outcome of the appeal itself.
Thank you. Just writing it up. So he's going to be pleading guilty to an added count 2 of allowing an ineligible person to drive. And my understanding, and I haven't seen it in a while, is that that is a misdemeanor carrying a maximum penalty of 90 days and or up to, is it a $100 fine, Ms. McDuffie?
Your Honor, I believe so. It can also be a civil infraction. I don't have a preference. He can have either one.
Okay.
Your Honor, we would request the civil infraction then.
I thought you might, but I'm not familiar with the civil infraction piece of it. Do we have a code for that? Do you know? Allowing an ineligible person to drive?
The only trick with that is I don't know what the costs are associated with most of the civils.
Okay. And that's a civil infraction. Okay, hold on one second, please. Do you have the PAC code for the civil infraction? Because what I know it to be is a misdemeanor.
Yeah, so it's one digit different. So it's 325 instead of 326.
Okay. We'll have to add it. All right, so give me the full number because we don't have that in our system.
Oh, I'm sorry.
Add it.
257.
Okay.
.325.
All right, sir. It's my understanding that you're going to be accepting responsibility for the civil infraction of allowing an ineligible person to drive. That is a civil infraction, and I guess I'll make up a penalty for you. So is that what you want to do?
Yes.
The fine in that case is going to be $200. Can you pay that today, sir?
Can I pay 100 of it today? Cause I been down. I've been off work. I got Ramadan, so I'm on bed rest right now. But I could pay 100 today.
Yes, sir. So you'll pay 100 today. Do you know when you'll be able to pay the balance?
I'll talk with my kids. They said they'll help me out because they're basically paying all the bills right now for me. I've been down for a month. My muscles is deteriorating.
Oh, I'm sorry to hear that.
Yeah.
I can give you some time. How long do you need, sir?
After I paid 100, if I could just pay, I'll just say 25 a month, but I'll pay it before then. I just want to be safe.
Okay, that's fine. I will give you that payment plan. On what day of the month do you want to pay that, sir?
The first.
All right. And then I'll bring you back on June 20th to see if you're making your payments, okay?
Okay,
If you're making your payments, you do not need to be present.
all right.
Count, 1 is dismissed. You're all set, sir. Have a good day.
All right, thank you, you too.
Do you want me to put it up here? No. Okay. State of Michigan versus LaShawn Taylor, case number 24S00015.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of LaShawn Taylor.
LaShawn Taylor.
Looks.
Hello, Your Honor, can you see me?
Yes. Please state your name.
LaShawn Taylor.
We're for
Yes, Your Honor. I'm asking for an adjournment to further speak with Mr. Taylor, who I will need to reach out to me, and to speak with Ms. McDuffie about any offers.
All right. We're getting full on April 4th. You won't. You haven't been putting them in, right?
Not today.
Okay. I mean, do we have, well, it's just going to show what you showed earlier, which was the 31, I think. I think we're going to have to put this out to May 2nd. You know what? I'll put another one on April 4th. April 4th, 2024 at 9 a.m. Bond is continued. Do you have his contact, or do you want to go into a room to talk to him?
Can I go into a can I go into a quick breakout room? Thank you.
Yes. Mr. Taylor, please don't leave. I'm going to put you into a room with your attorney real quick, okay?
All right.
Thank you, sir. State of Michigan versus Michael Foley, case number 22S00904.
Rachel McDuffie for the people.
Mike Foley, Your Honor.
Thank you. Good afternoon, Mr. Foley. All right, there is a violation of probation that's being filed in this case, Mr. Foley.
What did I violate? I was unaware of that.
I'm still talking.
Oh, I'm sorry.
I'm going to arraign you on that right now so you can hear what the violation is, okay?
Yes, Your Honor.
The violation is that you failed to complete community service, you failed to complete the MAD victim impact panel, you failed to complete the Greenbrook assessment, and follow all the recommendations. You're entitled to have a hearing on these matters, at which time, if it is found that you did in fact violate the terms of your probation, you could be sentenced to up to 5 days of Washtenaw County Jail. Do you understand the violations, sir?
Yes, Your Honor.
All right. Do you need to speak with your attorney regarding this, Mr. Foley?
Well, I don't have an attorney present today. Unfortunately, I lost my job in September and been unemployed for a while, so I couldn't afford him and wasn't sure what to do, so I showed up. But I did have a question on the violations listed, Your Honor, if I may ask.
You may not ask me questions about your violations. You probably need to talk to an attorney. So, is there someone from the Public Defender's Office that could speak to Mr. Foley?
Yes, Your Honor.
All right, I'm going to put you in a breakout room with Mr. Foley. Does your office happen to have a copy of the violations?
I am checking right now, Your Honor.
It was sent to everyone individually, as well as a misdemeanor address on Friday, the 8th.
I do have it.
All right, thank you. I'll put you into the breakout room, and He may want to retain counsel again. I'm not sure, but you can let me know. Okay? Thank you. I'll recall it when you let me know that. State of Michigan versus Daniel Sims, case number 23S00079, as well as 23S00539.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Daniel Sims.
Daniel Sims.
Thank you. I believe we need to go into a breakout room with respect to this matter. If I can have a breakout room with the attorneys and probation, please.
No.
Ms. White, I think your client, Mr. Taylor, is confused. He put it in the chat.
Okay, I'll try again.
It'll take us a minute to get you back into the breakout room with him.
Okay.
So is she going with Sims or? Is she? Was she?
I need.
Running around. You have to be patient.
Well, they're yelling at me.
All right, back on the Danielle Sims matters. Mr. Sims, what we would like to do, or what the court is going to do today, is sentence you on the 23S00539 case, which is the misdemeanor up to 90 days, and give you credit time served on that, and then we will bring you back on a different court date for the remaining 1 year matter, and continue your bond, which is PR at this time. Okay?
Okay.
Ms. White, as far as the 23S00539, is there anything you want to say on behalf of your client before sentencing?
No, Your Honor, just that we do ask for the credit for time, sir.
Thank you.
Thank you.
Anything from the people?
Nothing from the people.
Thank you. Anything you want to say, Mr. Sims?
When will I be back in court for the other one?
May 2nd, sir.
May 2nd, okay.
$90 days in the Washington County Jail, credit time served for 90 days. Fines and costs are waived. In the 20S00079, I'm going to bring back here on the May 2nd, 2024 at your sentencing is adjourned to then, sir.
Okay. And the bond is still the PR bond?
Yes, it is.
Okay, not a problem.
All right, sir. You're
All right. Thank you.
State of Michigan versus Gabrielle Blackburn, 20S00600.
Good morning, Ms. Richardson. Rachel McDuffie for the people.
Ms. Blackburn, I think you said something, but it didn't come through very legible.
I was just saying good morning.
Good morning. How are you?
Better.
So what's been going on? You say you're better. Yes. See, you weren't here at the last hearing, but I set it for a show cause today. What's been going on?
I was jobless, and then I got a job, and then I wasn't getting enough hours, and I just got a really good job. I work at Walmart now. So I don't know, maybe if we can set up a payment plan, or...
Yes, ma'am. How much can you pay per month?
It's bi-weekly, so like $150 a month.
You can pay that much, ma'am? Okay. So I will, what day of the month do you want to pay that on, ma'am?
I was gonna do it like $50 every 2 weeks. $50 out of each check.
50 out of each check is $100 a month, just so.
I get some months I get paid 3 times because I get paid early.
So are you gonna do 150 or 100?
100.
Okay. Saying don't overcommit is what I was getting ready to say. All right. So and then you're gonna do that what? I'll just make it the 15th of the month, however you get that paid by then, okay?
Yes.
And then I'll see you back here on June 20th, 2024 at 10 to see if you're making those payments.
Okay, thank you.
Thank you. Have a good day.
You too.
State of Michigan versus Erane Schaefer, 22S00600.
Rachel McDuffie for the people.
Assistant Public Defender Abby Lieba on behalf of Mr. Schaefer. Mr. Schaefer, please state your name, sir.
Erane Schaefer.
Thank you, Mr. Schaefer. Thank you for taking your hat on.
Yes, ma'am.
Mr.
Sorry,
Lieber.
sorry. What's that?
Okay, I was talking to your attorney. Have you had a chance to go over this report with your client? It sounds like we're in the same place we were last time.
We are.
I have, Your Honor. I have discussed the report with him. He is working on his community service. It sounds like he had some difficulty finding a place to do it at. I did give him a couple suggestions of where he can look into doing community service, including the Ann Arbor Nature Area Preservation and the Humane Society. He does tell me that he's been testing at Star Center and that he's going to be having them send the results to me and Ms. Straub. I can certainly
Already
contact
done.
that has not yet occurred. It looks like he's giving us thumbs up and saying it has occurred.
Ms. Straub is not here today, so if it was sent to her, I would not have it. All right, we'll just keep seeing if he can get this done. We'll be back here on May 16th, 2024.
May
At 10.
16th
Yes, sir.
at 10.
Yes, sir.
And I'm sorry, Miss Washington. You know I don't be like to let you down and stuff. I'm trying. I know that you told me like the holidays would be like a good time, you know. And I did try at church, but they wouldn't really open them. But it was either because I'm doing child support at the same time as this. You know what I mean? So it was
Gotcha.
either try to work and get the child support, take care of the kids, Christmas, holidays. I'm not trying to make excuse or anything. I'm just saying. So
Sure.
that's why I probably could have gave a better effort on the holiday, but it was either, you know what I mean? If you
Yeah.
understand, I hope.
Well, part of this is to try to get you off probation and get you
Yeah,
early charge, because if you get it done, you can be done with all of this.
right.
Miss McDuffie is going to point out something new that I need to know about. Go ahead, Miss McDuffie.
No, I remember last time Mr. Schaefer was here, he said that he was hoping to work out a 5-day straight, assignment with an animal shelter in Belleville. So I just wanted to be clear with the court. There's no restrictions in terms of the county where he has to complete that service. Is that accurate?
That is accurate.
Okay.
I mean, there's
And,
a preference, but no restriction. We prefer that it's done in Washington County or even further in our little local Ypsilanti Township, but there is no restriction on it.
oh, you don't want it to be in Ipsy? It can't be in Washington?
No, I said I would prefer that it be.
Oh, okay, because Mr.
But
David, he did give me some places in Washington because my kids live in Washington, so I'm out here a lot. So that'll probably be easier for me anyway. So it's probably like he said, the Ann Arbor. He also told me about the animal place. So I'll make it happen. I'll
Okay,
make it happen.
good. All right.
Thank you
Thank
for
you.
understanding. I
You're welcome.
appreciate
See
you.
you soon.
All right.
Bye-bye.
Yes, ma'am.
You have a good day.
You too. Thank you.
Thank you, Your Honor.
State of Michigan versus Derisha Nixon, case number 23 FB 1204.
Rachel McDuffie for the people.
Hi, Your Honor, Darisha Mixon.
Hi, how are
About
you?
time.
That you got called, huh? Well,
Sorry, I was just saying that because my son is driving me crazy right now.
oh, is it in the background?
Yes, I just made him go downstairs.
Okay. Well, Miss Nixon, it sounds like you're doing exactly what you're supposed to be doing right now. You're doing a good job, is what the report says. You've written your letter of apologies. You're attending your counseling. Is that working for you?
It is. It's definitely working a lot. Mainly just I'm in my healing process.
Oh, good. That is what we wanted for you. So I'm very happy to.
Yeah. Thank you. No, I was already looking for therapy on my own before this happened. It's just been hard finding different therapists. But this one I love. We don't just talk about this case, but we really get to the root of my pain, if
Yeah,
that makes sense.
it does.
And it's been definitely helping me.
Good.
For the long run. It's definitely I'm happy.
I can tell that is so genuine, and I so appreciate you saying it and
Oh, no
sharing it.
problem. No problem.
Anything from you, Miss McDuffie?
I appreciate Ms. Mixon fully engaging in what she needs to do for herself. And I remember how she first appeared before this court, and I haven't seen that person again. So I think that is effective in a lot of different ways.
Yes, agreed.
Yes. No, I don't want to be that person. I've never been that person before I met my child's father. And it's not a good feeling. I'm a mother. I lost my mother at a young age. Um, and that affected me a lot in my life. And so now my goal is to just be the best mother that I had before she passed away. And that's just been my goal, being the best me. Mainly being the best me first, because you have to be the best you before you can be something to others. But I'm sorry, my son is back upstairs. But
That's okay. That's okay. I fully understand
yeah.
everything you're saying, and you're very, very correct about that. So keep working, being the best you. Tell your
I'm so sorry.
That's okay. I'll see you back. I'm going to schedule you to come back in 90 days. That'll be on June 20th
Okay, yes, ma'am.
at 10 o'clock a.m. And again, you may be excused if you're compliant. Okay.
Okay. Well, I'll still come anyways because I want to see y'all faces.
That's
You guys are very pretty.
You are so sweet.
And yeah, so
Thank you. Thank you. Keep
I'll
up the
still
good
be
work
here.
and keep up the good work and keep delving and making it happen. Okay.
Sorry. Thank you so much. I really appreciate you guys. And thank you for, like I said, thank you for, it's your job to, do these things to help others be correct within themselves. It's your job, and not a lot of people care.
Yeah.
If that makes sense. So I really want to say thank you, Miss Washington, Judge Washington. Thank you, Miss Duffy, and I see Miss Sandra White on here. I know I see you.
We've been through a lot. I'm so happy you're doing well.
Everybody, because you guys made me realize who I am. I found myself, and my goal, like I said, is to be the best me and for my kids. So I want to say thank you. Thank you.
You're so welcome. And thank you for saying that. It helps. We don't get that a lot. So
I know you guys don't, and you need to. So I wanted to make that known because a lot of people don't see that, but I do. So I want to say thank you because it's not always bad, but the end goal is to help. So and that's exactly what you guys did. You guys, you're helping me help myself, and thank you.
You're welcome.
Thank you. I
Have a
really
good
appreciate
day.
you guys too. You guys have a lovely
All right.
day. Have a blessed day. Aiden, come on. Let me leave.
Yes. The court will recall the case of the state of Michigan versus Michael Foley, 22S00964.
Rachel McDuffie for the people.
Assistant Public Defender Davi Lee before Mr. Foley. Mr. Foley, could you state your name again?
Mike Foley.
All right, thank you. Mr. Lebo, you had a chance to speak with Mr. Foley.
I did, Your Honor. If we could have a brief bench conference, I believe that would be helpful.
Thank you. Yes.
Thank you, Your Honor.
No, it would be Miss McDuffie on probation. All right, I did have an opportunity to speak with Mr. Lebo and the prosecutor and probation regarding this matter. I understand that some proofs will be submitted regarding some community service that was done prior to the filing of the actual violation. However, some matters still seem to be outstanding, and Ms. Straub is not present today to provide her input on what direction she would like to see this go. I'm going to schedule for a violation of probation hearing, at which time Ms. Straub can have an opportunity to take a look at whatever documentation she has received and make a determination as to the direction that we want to go. The hearing will be without having witnesses present on that day, so it's simply a day for us to have more of a status conference regarding the hearing. And that is going to be on April the 4th at, I'm going to make it at 10:30. I'll set bond as PR.
Thank you, Your Honor. Would that be in person or on Zoom?
It's on Zoom.
Thank you.
The recommendation was never for any jail time anyway. So typically, unless there is, people don't need to come in person. Okay.
Thank you. I just wanted to be sure because of the time.
Yeah, even if they do continue with the violation.
Thank you, Your Honor.
We'll see you then. Okay, Mr. Foley.
Yes, Your Honor. Thank you.
Thank you. Wait, where? Oh, Zoom user. Okay, thank you. Yes. State of Michigan versus Deontay Connors, case number 23 FB 1053.
Deontay Connors.
Sorry about that. Rachel McDuffie for the people.
Thank you.
Assistant Public Defender Dobby Lebo for Mr. Connors, who has stated his name.
All right, it appears that we need to adjourn this matter because Mr. Connors has a new charge.
That is correct, Your Honor. I would note that Mr. Connors has told me that he's going to begin making payments in this matter next Friday, and I did go over with him how to complete the online reporting form, so I don't believe that will be an issue going forward.
Thank you. So it looks like he has jury selection, the 8th, and the trial is supposed to start on the 8th as well. So why don't we put this over to April the 11th and see where things are?
Thank you.
April 11th, 2024 at we'll do it at 10 a.m. via Zoom. Bond is continued.
Thank you.
Thank you, Your Honor.
Okay. There's an individual with the label of Zoom user. Could you please unmute and tell us your first and last name? And if you are still in the bathroom, please don't unmute. Please don't turn on your screen. And Mr. Moody's here from yesterday. I'm going to do that first. All right, the court will recall the case. Court will call the case of Ronald Moody, case number 23 FB 1303.
Rachel McDuffie for the people.
Mr. Moody, please unmute your device.
All right.
Good morning, Miss Jet. How you doing today?
I'm good. How are you, sir? Please state your name.
I'm okay. How you doing? Ronald Moody.
Thank you. Thank you very much. All right, Mr. Moody, it's my understanding that you're here today for your first review after you were sentenced back on December the 7th, you were incarcerated at some point and apparently you've been playing phone tag with your probation agent, who you need to reach out to make sure you're in compliance with your probation. So she said she called you and you haven't called her back.
I was just trying to play phone tag, Judge Washington. I just had 2 seizures at this and I was in the hospital for about 2 weeks, and I just got out and I just had 2 seizures. So I think I missed a court date, and I did just when I had my seizure. And when I had my seizure, I broke my phone, so I had to get a new number and a new phone. So I wasn't trying to play phone tag with her, and I'm trying to get back to the flow of things, and I'm trying to get everything. I'm not trying to miss no updates and no appointments or nothing.
Okay, I can appreciate that, sir. So she's going to give you some another opportunity. I'm going to adjourn it for 60 days for you to reach back out to her. Do you have her phone number?
My attorney,
Your probation agent, sir.
I think I contacted her. I think we did have a chance to talk.
Okay. Do you sure you have the phone number? You want me to give it to you again?
Yes.
Okay, you have a pen?
I can pump it out. Okay, I'm ready now.
All right, 734
Seven-
483. Are you frozen? Looks like he did. Let's stop his video. Yeah. We're going to stop your video, sir. All right, I'm going to keep giving you the number. But if you don't get it, just call the 14B District Court, 734-483-7336. Okay? And as for Ms. Straub, your next review is going to be on May 16th. I think I lost him. At 10 a.m. Okay. The court will call the matter of the state of Michigan versus Christopher Kopak, case number 23S00392.
Correction, McDuffie for the people.
Assistant Public Defender Don Lebo for Mr. Kopak. Mr. Kopak, could you state your name, sir?
Christopher Kopak.
Thank you, Mr. Kopak. All right, can I have a breakout room with counsel, please? All right, the court has had an opportunity to review the case law and to look into the court's training, which is called a bench book regarding, well, let me start over. This matter is back before the court today for a ruling as to the issue of whether or not the court has the ability to dismiss. It's actually before the court on the defense's motion to dismiss this matter based on the fact that the argument is that the prosecutor does not have the legal sufficiency of evidence to support the charge in this particular case. The court adjourned this from the hearing 1 week ago to look into whether or not the court actually does have the authority to dismiss a matter at the pretrial stage if there is, based on the allegations as they appear before the court at the time, not a sufficient basis for to make out the elements of the charge. In reviewing this, I reviewed the case law that was submitted by the prosecutor as well as the case law that was submitted by the defense in this particular case. The court's most salient instruction as to whether or not there's authority comes from the bench book itself. The bench book says that there is no court rule or statute specifically addressing a motion to dismiss a criminal charge. MCR 2.504 is the civil court's rule governing dismissal of actions. But ordinarily, a motion to dismiss in a criminal context is used to address issues such as double jeopardy or entrapment, where the remedy of the court is for dismissal, which those go to constitutional violations, as the prosecutor has previously indicated. And it goes on further to be more clear to say that the trial court exceeds its authority when it dismisses the information against the defendant at the pretrial stage of the proceeding. And that is based on the People versus Morrow 214, Mich. at 158. It says because the prosecutor has exclusive authority to decide whether or not to prosecute a particular case. So, and it would basically be an abuse of discretion for the court to dismiss for a reason that is not already provided by Constitution or some other law, such as the 180-day rule or something like that, unless the law provides the court with that particular power to dismiss. So it is the executive decision of the prosecutor to choose whether or not to dismiss, and this court does not have the authority to do so. For those reasons, the court will deny Mr. Lebo and the defense's motion for dismissal in this case.
Mr. Lebo, you are muted.
My apologies. Your Honor, at this time, we'd like to set this matter for a final settlement conference, and thank you for your thoughtful ruling in this matter.
Thank you.
And Your Honor, obviously, I guess I should make the record that Mr. Kopech is rejecting the offer that was previously extended in this case, for one. And my second question was going to be, I don't know if given that we have a brand new case with essentially the same allegations and same issue that just occurred in January, I don't know if the court is considering that as a bond violation or not. I know it's not charged yet because we just got it in, but I don't know how we wanted to address that timing.
I think the court would need more information about the allegations of the violation of the case to determine whether or not it's a bond violation. And I think it's much more complicated in these types of cases because I don't know if we're talking about another act of omission in this case or another or whether there was
it's not assault.
Okay, thank you. We're currently setting final settlement conference for April 25th. And you did place on the record that Mr. Kopech is rejecting any offers. Is that correct, Ms. Lebo?
Kopech, you are rejecting the prosecutor's offer and would like to proceed to final settlement conference and potentially jury trial. Is that correct, sir?
That's correct.
All right.
And that was a prosecutor's deferred, which means it would have been dismissed after completion of probation. I think it was an agreement to 18 months. So just to be clear, that's what's being rejected.
Thank you. Final settlement conference will be April 25th, 2024 at 10:30 a.m. Jury selection will be May 3rd, 2024. I'm sorry, I did that wrong. Final settlement conference will be April 25th, 2024 at 11 a.m. And jury selection will be May 3rd, 2024 at 8:30 a.m.
Thank you, Your Honor. If you could please repeat the final settlement conference date. I heard April, but I believe I missed the balance.
April 25th at 11 a.m.
Thank you, Your Honor.
Is there anything further?
Nothing from the defense, Your Honor.
That was a nothing from both of us, I think.
All right. Thank you so much. We'll see you then.
Have a good day, Judge.
Thank you. You too. State of Michigan versus Thomas Evans, case number 22S00430, as well as 22S00450.
Rachel McDuffie for the people.
Your Honor, Assistant Public Defender Alexis Plumai appearing with and on behalf of Mr. Evans. And Mr. Evans, if you could state your name after the jail unmutes you.
Thomas Evans.
Thank you. All right. Mr. Evans is here because he failed to appear for his review on January the 11th of 2024.
And we have a new violation, felony 2.
We have a new violation or a new felony or both?
I'm sorry, a new violation in the form of a felony warrant that I think he's getting rained on this afternoon.
What is that charge?
Those charges are, one moment, I just had to pull it up. Let's see, that's case 24B 1020. And count 1, firearms discharge in or at a building causing injury. Count 2, assault with a dangerous weapon, felonious assault. Count 3, CCW. Count 4, firearms possession by felon. Count 5, felony firearm.
All right. What's the date of that?
That offense date is October 10th of 2023. And yes, and he's in warrant status at Wayne County, it looks like too.
Well, that's in between the.
I believe the offense date on that is actually the 28th of December.
Oh, did I say that wrong? I'm sorry.
Okay. All right. I was, wow.
Yes,
Okay.
I don't know what type of dyslexia is happening right now because those numbers weren't even right. Sorry about that.
All right. Thank you. All right. What would you like to say about bond, if anything, at this time?
Your Honor, just with regards to the failure to appear, Mr. Evans seemed to be under the impression that he was not on probation. So I just wanted you to confirm that on the record. I didn't see anything to indicate that he was not on probation. And because I am fairly certain that he will be held on those new charges when he's arraigned this afternoon, I'm not going to ask for anything with regards to bond and just request a violation of probation hearing date.
It looks like he was sentenced on May 25th.
Yes.
To 24 months of probation. I'm not.
Yes.
What?
And that's what I saw as well. He wanted me to have the court confirm that for him on the record.
Okay.
Your Honor, if I may.
No, sir. All right. I think that the violation of probation documentation is not gonna need to be filed in this matter still anyway. So what I'm gonna do is schedule this for March the 28th. And then at that time, sir, you'll have your actual counsel that's gonna be with you, and you and your counsel can talk and provide me with whatever information you wanna provide me at that time, okay?
I can't ask a question.
What's the question, sir?
I was sentenced to probation when?
May 25th.
I was in here doing, I was sentenced to a year in the county, which was the maximum penalty on the case. And I chose to do the whole year instead of going to treatment. So
Well, that's what you wanted to do.
that's what I did. I did the
Okay.
whole year.
All right.
So after I maxed out on the case, it should be no other recourse.
Okie dokie, sir. All right, I'll see him back here on March the 28th. I mean, March 28th, 2024 at 10 o'clock a.m.
Thank you, Your Honor.
I'll just continue. Mhm. Okay. Zoom user present. Can you please tell us your first and last name? Zoom user, please tell us your first and last name. If you do not respond to my next request, you're going to be removed from the courtroom. Zoom user, please tell us your first and last name.
Evelyn Tubbs.
Who?
Evelyn Tubbs.
All right, thank you. Evelyn Tubbs, yes. She on a list to be seen or anything by the PD? Okay. The court will call the matter of the state of Michigan versus Evelyn Tubbs. Man, where are you at with all that noise going on in the background?
I'm on break. I don't know where I can go. I'm on break. It's raining outside. We have a break room outside break room. I don't know. I can try the bathroom.
Well, where you are right now is better. Can you stay right there?
Okay. All right.
State of Michigan versus Evelyn Tubbs, case number 23S00198.
Assistant Public Defender Allison Mueller here on behalf of Evelyn Tubbs. Ms. Tubbs, can you state your name for the record, please?
Evelyn Tubbs.
All right, thank you. So it looks like Ms. Tubbs has actively gotten engaged in the CCOP program, which is very good. Thank you, Ms. Tubbs. We appreciate that.
You're welcome.
She's scheduled to be released from her probation on July the 6th. She has an outstanding balance of $389, and we just want you to finish your CCOP and try to get some of your monies paid. You're gonna work on those things, Ms. Tubbs?
Yeah, I've been paying monthly.
You have been? Oh, okay. That's just
I gotta pay this month.
All right, thank you. I think we scheduled today for the CCOP, so it looks like we're just gonna continue the probation is what the recommendation is. Anything from you, Ms. Muller?
No, nothing, Your Honor. Thank you.
Okay. Anything you want to say before I sentence you, Ms. Tubbs?
No.
Anything from you, Ms. McDuffie? I know I did that backwards. Okay. All right. All right. Um, in this particular matter, you are to continue with your probation. Continue with the CCOP. And we'll do a review in 60 days actually she's scheduled to be off on July 6th. So I'm just gonna do it in 90 days, ma'am. You should have this done by then. June 20th, 2024 at 10, okay?
Okay.
And if you're done, I think they'll probably just discharge you and you won't have to be back here, okay?
Alrighty.
Thank you. So. All right. This Muller is still there. I can choose her. All right, I think we're gonna do the in-persons now, so we need to have people come down to begin that process. We'll be in a brief recess.
Court will call the case. I think we need to call it back in session.
Court to be court is back in session. Honorable Erane Washington presiding.
Thank you. The court will call the case of the state of Michigan versus Devon Ellis, case number 23 FB 1258.
Rachel McDuffie for the people.
Assistant Public Defender Allison Miller. I'm here on behalf of Devon Ellis, who sits to my right. Mr. Ellis, can you state your name for the record?
Devon Ellis. Thank you. All right, Mr. Ellis, you're here today because a violation of probation report was filed alleging that you tested positive for alcohol via ETG on February 23rd, 2024 in violation of the no alcohol condition of your probation. You're entitled to have a hearing in this matter, at which time, if it is shown that you in fact did violate the terms of your probation, you could be subjected to this is a technical violation, so you'll be subjected to 5 days in the Washtenaw County Jail. That is what is being recommended at this time. I think that's probably more due to the fact that Mr. Ellis continues to deny use, and then he had another incident that does not arise to the level of a violation, but his number had been called a couple of times where he needed some, he made an excuse as to why he could not go and test. And at this time, I think there's some frustration going on. Having said that, what would your client like to do?
Your Honor, at this time, Mr. Ellis does want to admit to the violation.
Please raise your right hand to be sworn, sir. You swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right. You may lower your hand. Sir, you understand you have a right to have a hearing in this matter, is that correct?
Yes, ma'am.
And you wish to waive that right and you're going to admit to the violation?
Yes, ma'am.
So is it true that you tested positive for alcohol on an ETG test for February 23rd, 2024?
Yes, ma'am.
I find that there's a knowing and willing admission of the violation. Are you satisfied, Ms. McDuffie?
People are satisfied.
Thank you. So what's going on with your client?
Your Honor, I've talked quite a bit with Mr. Ellis, and I guess the first thing I want to know, or want to let the court know, and I will address, what's going on with him specifically. I just want to let the court know that he is taking this very seriously. He's been in a lot of contact with me, as soon as he tested positive. The conversations that I've had with him recently compared to maybe when I first took on his case, it seems like he is doing well, and he is really wanting to do the best he can. There was some confusion because I know when he went in to test that day, the breath test was negative, and so I think he was adamant, I haven't had alcohol right now, and I explained to him the ETG can pick up farther back. He doesn't remember consuming alcohol. He's pretty sure in February he didn't, but he's on a lot of different medications. I don't know if, for example, codeine, I don't think that leads to positive alcohol.
No. You know what leads to positive alcohol? Alcohol.
And I told Mr. Ellis, and he's still thinking about if he did consume alcohol in February and if that's positive. I told him if it's possible, I told him he needs to just, be upfront with the court. If he slips up, the court knows that can happen when someone's recovering. It did look like his tests were negative for substances, which I know were the underlying cause of this case. He's really, doing well overall in recovery. I think he's brought here proof of the meetings he's been going to with friends. It's called the Friends of the Little House Recovery Center, where he's been attending meetings. He's really on track with community mental health. You're staying really active with them, right? And your mom confirmed that. So that's all going well. And I know this, I think, was the day after this positive test was the day after you were seen last, and so
yes, he was sentenced on February 22nd, and he tested positive the next day.
And Your Honor, I just would emphasize, at least Mr. Ellis did say that the day of he didn't blow a zero, so I would hope that he didn't consume alcohol that day or the day of the positive test. But I think, again, with the underlying charges, it seems like he has tested negative for drugs. So he's doing well on that end, and that was what this charge was all about. Of course, he needs to abide by the conditions and not consume alcohol, and if he is struggling with that, he needs to also seek help with that. But I do really believe he right now is doing the best he can. I know he, in the report here, it mentions he tried to reschedule testing. Him and I had more conversations that that's just not going to be possible. I know the funding again was an issue, and I think testing popped up several times in that first week, so it was kind of an issue of funding. His mom told me he's been approved now for Social Security. That should be coming in very soon, so funds will not be an excuse going forward. Mr. Ellis and I talked. It's very clear to him now that he can't, reach out to Agent Straub and request not to test or to reschedule, that he's absolutely got to be there when his number comes up.
Well, I mean, sometimes there are exceptions to the rules, but the problem for Mr. Ellis is that he's been having this issue since the beginning of this case. We, on December 5th, had to issue a bench warrant for him because he simply, it looks like, failed to appear at that time. And then the warrant was recalled. He had to admit at that time the felon to test. This was on January 18th. He had not been testing since November to January. So he then got reinstated with testing and was to test within 24 hours. And I scheduled him for sentencing. In the interim time, he had another violation and got another one. Then he got that one recalled by the magistrate. And then he failed to comply again. I had to issue another bench warrant. We finally got him sentenced, and then the next day he tested positive. So his history is a part of the problem.
I totally agree, and I think Mr. Ellis agrees that his history does not help him today. The court has given him many chances. That's why I would just highlight that for me, his demeanor since I've started working with him has just been different to what I feel like his record reflects. Like this morning, he called me several times, texted, he was so worried that he was running late. He said, I'm going to be there at, 10:15. And I said, because he had caught I think had missed one bus, but, jumped on the next one as soon as he could. And I said, don't worry, you're going to be here. It's fine. And, of course he shouldn't have ran late, but he was just so worried that he wouldn't be here right at 10 when his hearing was set for. And I said, it's okay. I think your case won't be called, but just get here as fast as you can. And, he's here today in person. And I had incorrectly told him it wasn't. I thought that the sentencing would be in person. But, to be on the safe side, him and his mom were here in person. And, I think not the positive test that happened on the 23rd, but everything besides that in the last month to me points to that he is taking it seriously now. And I just would hate to see him get derailed now when it seems like he's putting in an honest effort and doing everything he can, especially with, mental health. And I think he just has got to get this testing, and I understand there can't be any more positives. And if I could make a recommendation for what we'd ask for today, is that if the court would consider adjourning the sentencing with the understanding that there cannot be any missed tests or any positives between now and the sentencing, and that would be the defense's request today.
Ms. McDuffie?
So the court, I would agree, is absolutely correct with respect to the history and what role it plays here. And what I see that concerns me is that this is Mr. Ellis's third controlled substance felony that has been reduced to a misdemeanor, and that goes back to 2014. Now, I can't control what's already happened and deals that were made by other people, but I'm concerned that's actually part of the problem, which isn't his fault that he got those deals, with him not understanding the seriousness of not only the criminal offenses, but his own substance abuse problem. I think there's a minimization that's occurred in the system when things are quote unquote just a misdemeanor. Not that that's not serious, but I don't have any testing updates since that February 9th report. So all I know is that he had this alcohol positive. But on that report, after that second bench warrant for not testing, those were benzos that showed up positive. And I don't see any prescription. Maybe that most recent report reflects it, but I don't know if we have anything to reflect the prescription. So if he's going to be issued a bench warrant for future positives, we might need to address that. I didn't see benzos show up anywhere else, but he hadn't been testing either, so who knows? Just so that everyone's aware, we have a new warrant request for Mr. Ellis. However, it's not going to be a violation because that offense date is, I think, not only prior to sentencing, but maybe prior to his arraignment in this case, is October of 2023. So the offense date is older, but I don't think he got arraigned until possibly being picked up on that. But so I realize that's a bit older, but even that, that's something that's involving multiple controlled substances, open intox, et cetera. So Mr. Ellis's problems, I think, are deeper than he comprehends. And he has said repeatedly that he doesn't have the money to test. I understand there's an expense and money doesn't come out of nowhere, but that's not going to be a reason that we leave him using, right? So he has to figure something out. The answer is to stop using, but you still have to test so that we can see that. And I don't know I take Miss Moeller at her word that she's looking at a more recent report than the one I have, and that those have been negative for substances over the last month.
Could you send that report to the both of us, Ms. Mueller, if you're saying?
Your Honor, I was just pointing to the report from Ms. Stroud from March 6th, where it says, the agent allowed him to test the next day on February 28th, at which time he was tested for drugs only and the test was negative. So I'm sorry if I misspoke. I only meant that. That's the only test I know that was negative for substances. I was just saying there was a negative for substance. And Mr. Ellis did say he tested. I tested in March. I don't know the date of that exactly. But I don't have a report to that.
11, 10, who's the author of the report you have, Ms. McDuffie?
Let me pull that up. The community corrections report that I have for him from January was Agent Wild.
Oh, well, you know what, Ms. Johnson, are you able to look and is she here? She is. Hello again, Ms. Johnson. Are you able to look and see if they show testing for Mr. Ellis in the system?
I can pull up community corrections drug testing results right now, Your Honor.
Thank you.
So he was negative on March 3rd. He missed on March 13th.
So he missed yesterday.
What does February look like? Because I think the last report date we have was February 9th was the last report date that we had.
So February 12th, he missed. February 16th, he missed. February 22nd, he missed. February 23rd was a positive ETG. February 27th was a missed. February 28th was negative. February 29th was missed. March 4th was the negative, and then yesterday was a missed.
Thank you.
Thank you so very much.
You're welcome, Your Honor.
That speaks for itself, Your Honor, that we obviously can't be assured. I appreciate that one or two of those in there was negative, but when it's following a series of missed tests, given his history, there's no assurance whatsoever that he's not using.
You may speak, Ms. Mueller. I have the same concerns as the prosecutor. He's testing when he wants to test.
Your Honor, I do know yesterday, and this isn't, an excuse for the whole day, Mr. Ellis was in court with Judge Simpson yesterday. And so he was preoccupied by that. And I know, 14A is right there, but it sounds like. Check on the communications after. So he didn't call to see if his number was called. He was preoccupied by court yesterday with Judge Simpson and knew this was coming up today. Your Honor, I know those are some missed tests. That is concerning. And this is not he tested, much more than he had been. Of course, he needs to be going every time. I stress that to Mr. Ellis. He knows that he cannot miss testing for any excuse. And so we apologize to the court that those tests were missed. There's really no excuse after kind of the history that we've had here. Again, the defense's request would be to adjourn the sentencing out with the understanding that Mr. Ellis cannot miss one more test between now and sentencing and cannot have another positive. I should add too, I don't know if that helps in any way. I know Mr. Ellis needs to be testing for substances, so there's no way to remove that. He's has expressed that he'd be willing to do a strand tether or a sober link to help with the alcohol testing, or if the court would consider putting that on in lieu of the alcohol testing. But of course, he needs to be testing for substances, so the request would still be to allow him to do that and adjourn sentencing out.
And what are you requesting, Ms. McDuffie, so we're clear?
Your Honor, I appreciate Ms. Moeller's advocacy and hope and confidence in her clients. I truly do. But when we were here on February 22nd, the court said that if he missed another test after that point, a bench warrant was going to issue, I believe. So Mr. Ellis is not in a situation where he can even make that promise that he's not going to miss another test. We started out trying to get to his sentencing with 17 of them that he had missed at that point, and he's just missed ever since then. And when he hasn't missed, for the most part, he's tested positive for something, with a couple of exceptions in there where he tested negative. This problem is over his head at this point. He doesn't have control over his use or his testing. And I don't know what the long-term answer is, but the short term is not to trust him to do it moving forward.
Anything you want to say, sir?
That I can do it. I had quit marijuana. I had quit cocaine. I had quit like everything, and I still attend meetings. I'm not making no excuse or anything, and I definitely think I can still finish this probation out because I'm so confident, and then I'm still around positive people, and I let a lot of stuff go these past months and stuff like that, and I no longer do drugs. I was coming from doing it a lot, and I totally don't do drugs anymore. And
how am I supposed to know that, sir? You're not testing regularly.
It was a money issue, but which is not going to be no issue again. And I will continue to come to court every time y'all want me to, as scheduled. And I just want to stay in a positive mind state that I can do it, and I know I can do it for sure.
So part of the problem I have is I don't know how 5 days gets us much of a difference in his situation. Not that the recommendation is wrong. That is what we're allowed to do at this time. My thing is that he actually needs probably inpatient treatment, but I'm gonna let him tell me whether that's true or not. And sir, let me tell you, this test is considered a positive test. If you don't go, you're positive. Do you understand?
Yes, and I'm so sorry about that, Your Honor. I apologize to the court.
I'm not gonna sentence you today. I'm gonna wait and see if you miss another test or you drop positive. I think you'll let me know in less than 2 weeks, so I'm gonna bring you back in 2 weeks on March 28th.
Thank you so much, Your Honor.
At 11 a.m. in person again.
I will definitely be here.
That's for the sentencing. You're welcome. Like your mom?
Yes.
That's why I am. Oh my goodness. Oh my goodness. The court will call the matter of the state of Michigan versus Erane Edens, case number 23S00156.
Rachel McDuffie for the people.
Assistant Public Defender Sandra Wright on behalf of Elijah Edens.
Thank you. Please state your name, ma'am.
Elijah Edens.
Thank you. You may be seated. All right, Ms. Edens was here on February 29th, at which time she was arraigned on 3 violations and told to show back up on March 7th in person, and was given a PR bond. She was to complete a Scram tether download within 24 hours, which I see that she did do at that time. She didn't show back up on March 7th. She indicated that she was ill, and we gave her a pass and scheduled it for today's date. We have a number of violations pending. Right. One violation alleges that she failed to report for the Scram tether download since she had it put in place. That's from February 27th. February 4th was that she tested positive for THC and alcohol in violation of the no alcohol or marijuana condition of her probation. And then the first violation was for her failing to complete the MAD victim impact panel within 45 days and failing to report to probation as needed and failing to drug and alcohol test. What would you like to do today?
Ms. Edens is going to admit to those violations.
Ms. Edens, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Ma'am, you understand you may lower your hand. You have a right to have a hearing in these matters. You're choosing to waive your right to have a hearing in all 3 of these separate violations?
Yes.
And you're going to admit to them?
Yes.
So for the first violation, is it true that you failed to complete the MAD victim impact panel to report to probation as ordered and to drug and alcohol test as ordered?
Yes.
All right.
I'm sorry about that.
That's okay. Wait, well, are you saying you're sorry for taking time to not answer or for the violation?
Well, because I had, it was a mix up with that. I did complete it, but I didn't get the certificate, so I'm redoing it. So that's why I asked, I'm like, would I still say yes? You know, so I just had a question, that's all.
Okay, thank you.
You're welcome.
And then tested positive for THC and alcohol in violation of the no alcohol or marijuana conditions of your probation, is that true?
Yes.
All right. And is it also true that you failed to report for your Scram Tether download effective February 27th, since you had it placed on February 2nd?
Yes.
All right. I know you have done it now, but you were in violation at that time, correct?
Yes.
All right. Are you satisfied, Ms. McDuffie? I find that there's a willing and knowing admission to the violations.
The people are satisfied.
Thank you.
Oh, well,
Yeah, go ahead.
I'm satisfied.
So I think that, is there something you'd like to say on behalf of your client before sentencing?
Yes, actually, there's a lot Ms. Evans would like the court to know, if it's okay. I believe you're in receipt of the letter of completion. I tried to print it out, but it kept printing really weird. She doesn't have the 12-step meeting sheet, but she said that she had to complete that to get the Dawn Farms completion. So she will call Dawn Farms if necessary to get a copy of the actual meetings. She's done 50% of the ARM class, and she has until March 26th to complete that. She's going to start community service. She was supposed to start today, but she had to be there at 12:30. So she's called and they said that she can come on Sunday. She has done the Scram Tether download twice. She started the MAD Victim Impact Panel, and she has
Let's talk about that.
Okay, sorry.
No, I want to talk about that.
Oh, you want to talk about that? But
yeah, the MAD Victim Impact Panel. She had some interesting comments with respect to her quiz.
What? I'm sorry.
What is the purpose of the MAD Victim Impact Panel?
Mothers against drunk driving. I'm sorry, right?
Gotcha. Okay.
It's been like videos.
Well, what's the purpose?
I'm sorry.
What's the purpose? To help you understand the devastating potential results of your choice to drive while impaired, right?
Yes.
Okay. So I take it that these are options. Did you see the questionnaire that came over, Ms. White?
No, I did not.
Did you send this over?
Hold on.
So at first I read it and I was like, what did she say? But I think it's just options and she chose option 2.
Oh, okay.
Because at first I was very concerned. Do you see what I'm saying?
Oh, I didn't completely sign in when I took the screenshot. That's probably what it is, but I'm at 23% for it.
I thought she wrote that.
Oh, okay.
That just was an option. Is that correct?
Yeah.
Okay.
It was just a screenshot so I could get my progress so you can see that I'm enrolled in it.
Okay, thank you. Do you have this, Ms. McDuffie?
I haven't.
I just.
Okay. All right, now you can proceed.
Okay.
My mind was distracted by that, so
Okay.
I needed to understand. Go ahead.
She has been making her monthly payments. We are asking the court, if it's possible, and I think I've made this request before, to have the Scram Tether removed because it's affecting her sciatica. She also has started at Buffalo Wild Wings, and she's getting trained in several areas, and one of them may be bartending. She has already talked with
I don't think she can do that.
Okay, she talked to Community Corrections, is it Community Corrections she talked with? Yeah. And they told her to get something sent over, and in that way, if she happens to spill alcohol or anything, they'll all be
There's a no alcohol condition of her probation. How does that not violate it?
Okay, so we'll just have to tell her.
Can you around it, possess it, or?
Well, that's part of our questions.
I don't think she can learn to bartend. I think I might make an exception if she was trying to get work and employment there in a different capacity. I might consider that, but bartending, I'm not.
Yeah. She actually is, your current capacity is?
I'm currently a cook as of now.
Okay, and they wanted to cross-train her in other areas, but she can tell them no to bartend.
Okay. Ms. McDuffie, do you have something to say about the bartending piece?
I'll hold my comments till the end. But about that, I was just getting ready to do some math because I know Miss Edens was underage at the time of this incident. I don't know if she's 21 yet, but That's another thing.
She is, she says.
Okay.
So you understand you cannot do.
Yeah, now I know. Okay. Okay, and I have a question, because sometimes, can I ask it? I'm sorry.
Not quite yet.
Okay.
All right, so our question was to switch to a sober leave, if possible.
Thank you.
It's hard to see, I think I have more. Yes, she's going to be getting a medical marijuana card, which she'll be picking up the letter from the doctor.
Well, I have the card. It's the
Letter
from
of
the doctor. From the doctor.
Yes.
The letter of necessity.
Yes.
All right, Ms. McDuffie.
First, I'll say thank you to Ms. Edens for getting compliance with the requirements and sending proofs of that. I know that her agent needs to personally see it and receive it, but at least we can see that some things are happening. My biggest concern here is, especially when it relates to MAD, Ms. Edens herself was a mother, right? Engaged in this type of driving. And it was, anytime I have a case, a drunk or drug driving case or a combination of both, and I reduce the charges against my better judgment, I have regretted it every single time. I currently regret it in this case because I took this down 2 levels. It was a 1-year offense. It could have been taken down to high BAC, and it went all the way down to OWI. And with Ms. Edens being underage, at least at the time, we had a lot of SoberLink violations, like a bunch of them, to the point where they adjusted her times for her job so that she can work. That was supposed to be the issue, but it was still an issue. And we always have a concern that when somebody's testing late, that even if those results are negative, that they're finding a way around that timing. And so it's very discouraging to see any presence of alcohol come up after that point, because it makes me wonder, right, what are the background issues happening? What is happening where somebody who isn't even age eligible, I don't understand that she's 21 now, but who is turning to alcohol for some sort of self-help? Or maybe not. I don't know, but I don't know what those issues are. That's kind of the point. What are the issues? I know Ms. Edens is getting herself in order, and I know that she's engaged in these things, so I have to trust that the programming is doing what it's supposed to do. But that's where my concern lies, is if she's requesting today to get back on SoberLink, I would object to it based on the trouble that we've had. I know we've had trouble. She needs to report for downloads on time, but at this point with her, my preference is that she stay on the scram, because it's, and obviously she needs to go regularly. She reported this time after almost a month. We learned that data gets wiped. I don't know if it goes in chronological order. I don't know if the scram data starts to be lost from the oldest to the newest. So Ms. Edens, it's extremely important, if she does stay on the scram, that she reports. I don't know if it's every week, every 2 weeks, but she has to go. But I want to stay on top of her use because I'm really concerned about it. This case is going in a direction I didn't think it was going to go.
Thank you. So before I hear from Ms. Edens, I'd like to hear about this. You made a blanket statement that is bothering her sciatica. In what way?
Because I'm on my feet. I'm on my feet all day, and I got it on my left leg, because normally it triggers my right leg. But with me working my new job and being on my feet all day, it's triggering it. Like, I'll just be at work, and sometimes, like, they didn't have to send me home a couple times because I've been in so much pain, and I can't just walk off the line. So they told me maybe to see if I could do something. I told them about my SoberLink, and I told them, like, if I was to see if I could transfer to do that instead, like, would I be able to go take breaks to go blow through it and, send my test. And they told me to see if there's something that I could do, or otherwise I'm going to have to get like a different position or cut my hours at work.
Well, I think, anything else you want to say before I make my ruling? It's your opportunity to talk right now. So,
me?
Yes.
I would definitely like to apologize for my violations, and I also was not aware at the time with my scrim that I was supposed to be going in to be getting it downloaded. So I did not know that. That was another reason why I did not go get it downloaded. But once I found out that I was to go every week, since when I seen you on the 29th, I went. And then when I was sick, I did not go last week. But this week I went, and so I'm to go every Tuesday to get it downloaded.
Well, they have
And-
you sign a contract when you actually get your scram tether.
And I just got a copy of that as well. So, because I did not get it when I first went. So when I went on Tuesday, I just got my copy for that.
Well, Ms. Evans, this is the thing. Once you've tested positive for alcohol, we get much more concerned about what's going on with you, and that's why you're on the scram tether. And so I'm not willing to just let you off of the scram tether. I will do that if it is a real medical issue. So that means you need to get a letter from your doctor.
Yeah, that's what I'm going to pick up when I leave here today.
Saying that it's a medical issue and it
Yeah.
causes issues with your sciatica.
Yes,
I'm not
ma'am.
trying to have someone be in pain. If it's documented that that is so. So upon receipt of a letter, I will consider that, removing that, and put you back on the sober link, but not without something from a doctor indicating that it does in fact affect your sciatica.
And I explained to my job with that as well too, with how like the time, 'cause normally I close. And I know like when I was on it, I had to test between like 9 and 12, and I will be at work around those times since I'm doing afternoon. So I already explained to my job, like if it is approved by the judge, I will need to be taking breaks between those times to go and blow. And they told me that it would be okay, because I know that was the issue with my other job at first, why I had late tests sometimes or missed tests, because it was an issue with my other job. But since I explained to them up front with this one, it would be different if I was be placed back on it.
It is the sentence of this court that you serve 5 additional days of community service for the VOPs for a total of 11 days, 88 hours, which is due by June 1st. So you gotta get those done by June 1st.
Okay.
You'll continue on your probation, and we're gonna have a review in this case in 60 days on May 16th, 2024.
Okay. I have a question.
That'll be at 10 a.m. now.
Okay.
And I can be back on Zoom, okay?
Okay. So when I get my letter, will I bring it back up here to the court, or will I email it to my attorney?
You would email it to your attorney, who will email it to both myself and to the prosecutors for me to make, to consider that. Okay?
Thank you.
You're welcome.
And thanks for my second chance.
Yeah.
I appreciate it.
You're welcome. I think it's the best attitude I've seen you had since you've been back here, I don't know what changed for you, but you should keep working in that direction, because it's a much better look, first of all, and it's gonna get you much further in life.
Yeah.
So, good.
I'm really trying. I am.
Keep up the good work.
Thank you.
Okay, thank you. All right.
Thank you. That letter too. And
keep in contact with me.
Okay, I will. Okay. Thank you.
Okay, one more.
It's gonna have it.
All right, the court will call the cases of the state of Michigan versus Raw Enterprises LLC. 23S 416461 A and B.
Rachel McDuffie for the people.
The court put these matters back on the docket because we have got no responses from anyone from Raw Enterprises. And the court would issue a bench warrant, but there is no individual to issue the warrant for other than who we have as Reg Anthony Wilson, who is the, I believe it's the resident agent for the company, but we don't have the information to be able to provide that bench warrant. So I don't know whether the prosecutor is willing to assist with that process, given that. Go ahead.
Normally what I would do, so we don't have a discovery request because there's nobody requesting it. But the court has a copy of the ticket, I believe. If the court could send me a copy at some point of the actual citation, it'll help me to follow up as best I can.
All right. So at this point, what I'll do is, and I put it back on the docket because we had the initial pretrial where there was a failure to appear way back in 2023, and any opportunity for a bench warrant had already passed. So what I'll do to track it at this point is schedule it for one more pretrial, where in the interim time period, the court will send you a copy of the discovery, and you can determine whether or not there is anything you can do to assist with the issuance of a warrant. I'll schedule this for May 2nd, 2024 at 10 a.m. No, I'll do it at 9, my standard time, 9 a.m. State of Michigan versus Eric Martin, case number 24S00425.
Richard McDuffie for the people.
Assistant Public Defender Sandra White as standby counsel.
All right, defendant failed to appear at the last hearing, and he's failed to appear at this hearing as well.
I tried to call the numbers that I have and they are all disconnected. So I guess on his behalf, I would ask for a show cause.
We did a show cause last time, but thank you.
And one more thing, Your Honor. So I saw in GIS that as of, I believe, Valentine's Day, there was a letter submitted or something. And I do recall being in chambers, I think right before our last jury trial, and seeing from a distance, I think somebody had left a file on your desk, and I recognized the manner and style of his handwriting in the documents he usually submits. So I do think something came in, but I haven't seen it. So I don't know what that was. And
it is his allegation that he's filing a federal lawsuit against me.
Oh, we knew that.
So,
okay.
Okay. So that's what that is.
Thank you.
So at this point, bench warrant will issue in the amount of $10,000, 10%. State of Michigan versus Sandra Law, case number 22S00563.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Sandra Law. I did speak with Ms. Law last night. She is very sick. She sent me something. I told her I would need a doctor's note on doctor's letterhead with doctor's signature. She was going to send me that. I don't know what happened. Like I said, she is sick, so I would be asking for an adjournment or a show cause.
Ms. McDuffie.
Miss Law, of course that screenshot she sent was unacceptable in every way, she may very well be sick right now. I think the issue is that she continued to fail to test after she was here and begged and cried and everything. And we still don't have the information we need as far as we still can get her sentenced. And Ms. Law is the prescriptions information I received was outdated, which was the whole point of getting that. So Ms. Law is, I mean, I just feel like we're done here. It's not necessarily just because of today, it's because of everything, even after our last hearing. So I think a bench warrant is due. And, you know, I'll leave the amount obviously to the court's discretion.
Thank you. I too find the letter unacceptable. It does not document any type of information for this court to be able to make a decision or determination that there is a critical illness that would prevent her from being in court today. This is not the manner in which letters are written to a court in order for a matter to be adjourned or delayed on behalf of anyone. That letter is not acceptable. Ms. Law's appearance here is not acceptable. We've come way too far down the road with Ms. Law and having her write these types of letters and failure to appear and failure to actually test. And she just will not remain compliant in any way, shape, or form. Bench warrant to issue in her case, no bond. State of Michigan versus Devin Collins, case number 18S00265.
Rachel McDuffie for the people.
Sorry, Your Honor. I somehow muted the whole system. What was called?
Devin Collins.
Devin Collins, sorry. Assistant Public Defender Sandra White on behalf of Devin Collins. Mr. Collins hold on, I'm sorry. Mr. Collins texted me that he's having Zoom problems. We did talk last night. He was hoping to make payments very soon, as soon as he got his taxes. So I would just ask for an adjournment of the review or a show cause.
So you're saying he hasn't made any payments since January?
Correct.
It looks like he was here at the last hearing. Show cause in this case will be, go ahead, Ms. McDuffie.
No, I was saying he paid the same day he appeared last time.
Show cause in this matter will be scheduled for May 2nd, 2024. And that is going to be at 10 a.m. Bond is continued. 10 a.m. No bond. We're not doing with bond cases. Got distracted. Sorry. State of Michigan versus Dorian Hudson, case number 20S00594.
Rachel McDuffie for the people. I don't know if it's a PD case, but he paid $200 on March 8th.
Yes, it is. It's mine. Assistant Public Defender Sandra White on behalf of Dorian Hudson. And yes, he did make a payment.
Sorry, Sandra. I was trying to be efficient.
I'll schedule this for June 20th, 2024 at 10. One moment. Audio is out. Roll call the matter of the State of Michigan versus John Mitchell, case number 18FB1742.
Rachel McDuffie for the people. Excuse me, I'm sorry.
Not ours.
Assistant Public Defender Davi Leva for Mr. Mitchell. It does not appear that he has made any payments, and I have not been able to have contact with Mr. Mitchell. It does not appear that I have a good number for him.
Thank you. Mr. Mitchell did appear at the last hearing on January 25th. I will issue a show cause for failure to appear, failure to pay. And schedule that for May 2nd, 2024 at 10.
Thank you.
State of Michigan versus Benito Montez Rivera, case number 18-00415.
Rachel McDuffie for the people.
He failed to appear and failed to pay at the last hearing. Let me check to see if he has paid. No payments have been made. Defendant, bench warranty issue. What's the amount outstanding?
$638.40.
5,000, 10%. State of Michigan versus David Phelan, case number 18 FB 1685.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of David Phelan. I did attempt to reach out to him. His phone number is disconnected, but I do see he made a $100 payment on March 8th.
Thank you. June 20th, 2024 at 10. State of Michigan. Oh, this is David Phelan also. I'm gonna set it for the same date. I need to also call case number 18 FB 1910. State of Michigan versus Joshua Steinke, case number 23S00339.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Joshua Steinke.
All right, Mr. Steinke, it appears is still in residential treatment. Is that correct?
That was my understanding, Your Honor. I didn't have contact with him. I just saw the report that he was still there. So I believe that's correct.
Yeah, I guess the last update we have is from 2/28. So our assumption is that he's still there. Because he just got there on the 23rd.
Right.
Okay.
All right, I will set it out to May 2nd, 2024 at 10 for review. State of Michigan versus Gerald Ward, case number 20S00552.
Rachel McDuffie for the people.
Defendant failed to appear, failed to pay at the last hearing. If someone could check to see if he made any payments.
Nope. I'm sorry, that was unprofessional. No, Your Honor, I don't see any payments.
Warranty issue. $5,000, 10%. State of Michigan versus Jerry Williams, case number 16FB1557, as well as 15W006805B.
Rachel McDuffie for the people.
Assistant Public Defender Allison Mueller here on behalf of Jerry Williams on the 16 FB matter.
Thank you.
You're excused, I think.
Yes, they are excused from today's court date. We'll put this over to June 20th at 10 a.m. State of Michigan versus Darius Works, case number 23 FB 1734.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Darius Works. I was not able to get in contact with Mr. Works. I would ask for another show cause.
Defendant failed to appear and failed to pay at the last show, at the last review when it was scheduled for today's date because all he had was payments left, but he has failed to appear and failed to pay again. Still on, let's see. I think he's still on, let's see, ever on probation. He's still.
I believe so, because there was a report.
There is a report, yes. He's on probation still until June 7th, and he's just failing to appear to court and isn't making payments. Bench warrant to issue. I'll make it 2,500, 10%.